Welcome to this MI lunchtime seminar. We're very happy to welcome Professor Simon Halliday, who is Professor of Social Legal Studies at the University of York. Simon's also a member of the Chronic Disorders of Consciousness Research Centre, a multidisciplinary research group based in various UK institutions. And Simon has been here, he was just telling us, for 3 months now as a visiting scholar at the law school here at Edinburgh University. So today Simon's going to be offering us an assessment of the court's role in the withdrawal of clinically assisted nutrition and hydration from patients in a permanent vegetative state. Simon will speak for about 30 minutes and then we can open up the floor to questions and discussion. So,
thank you very much. Let me start by apologising for the length of that title. That's quite a mouthful. Sorry for that. It's descriptive rather than aesthetically pleasing. I'm really delighted to have the chance to give this paper, because it's not only a chance for me to kind of share this research that I've been working on with some colleagues in York, but it's also a nice way for me to formally say thank you to the school for allowing me to be a visiting scholar, which has been a very nice and productive experience. As you can see, I'm a member of this research centre, the Chronic Disorders of Consciousness Research Centre, which is, again, not a very snappy title, but very descriptive. And we have a team of researchers from various disciplines, based primarily in the Universities of York and Cardiff, looking at various issues and asking various questions around the topic of prolonged disorders of consciousness, medical patients who are in coma or in a minimally conscious state or in vegetative states. And much of our work our preliminary work, we're still in fairly early days, but much of our initial work has been funded through this funding platform here at the University of York, the Centre C2D2, the Centre for Chronic Diseases and Disorders, which is in turn funded through the Wellcome Trust. And one of the very nice funding schemes it has, which we were fortunate enough to get some funds from, is what's called a discipline hopping internship, which was we would get smart young postdocs to work across disciplines to sort of expand their disciplinary horizons, and in turn for us to have our own disciplinary horizons extended. So we were very fortunate to get this young chap, Adam Formby, young, bright social policy scholar, and now at the University of Leeds, to work with myself in the law school and with my colleague Richard Cookson in the Centre for Health Economics around the topic of patients in the permanent vegetative state. And what we were interested in particular was decision-making around the withdrawal of clinically assisted nutrition and hydration on the grounds that it's deemed no longer in the patient's best interest to be maintained in life. So you will know that patients in the PBS are maintained in life through the provision of artificial nutrition and hydration. And it is often the case that after time, clinical teams and families will agree that it's time to let the patient die. It's no longer in the best interests for them to continue in life. And we were interested in that particular form of decision making, and specifically in the interesting legal requirement in England and Wales that decision, before it can be put into effect, requires a declaration of lawfulness from the Court of Protection. So even where clinical teams and families agree that it's time to let the patient die, you then have to make an application for a declaration of lawfulness, a declaratory relief, as we call it, before the artificial nutrition and hydration can be withdrawn. And what interests us particularly, we can see the rationale for that where, for example, families disagree with doctors about what's in the best interest of the relative. But what interests us and what we're focusing on in this paper is in cases where there is no disagreement, where all the parties concerned think that it's best for the patient to be allowed to die, but that there's still this formal legal procedural requirement. Now, it might be useful. Most of you will know this, but just in case some of you don't, let me very briefly give you a background to where this procedural requirement comes from. And it can be traced back to the very well-known decision of Anthony Bland, which was the first time that the UK courts were asked to consider the situation of a patient in a permanent vegetative state. He was a young football fan who was catastrophically injured in the Hillsborough disaster, which rendered him in a vegetative state that was in due course diagnosed as a permanent vegetative state. And the doctors and families came to the view that it was time to let Anthony Bland die by withdrawing his life-sustaining treatment. But because of the legal anxieties at the time, this was a first case of its kind, and because of concerns over the prosecution of the doctors for criminal charges for murder, they sought a declaration of lawfulness, and that was considered all the way up to the House of Lords, and the House of Lords set a lasting precedent that it is not lawful for Anthony Bland or a patient in the PBS to be maintained in life by artificial nutrition and hydration, and that it was lawful for that to be withdrawn, and that the cause of death would be the pre-existing injury rather than the withdrawal of the AH. And in terms of this specific procedure of getting declaratory relief, the House of Lords framed it as being a matter of good practice for the doctors at the time. Not a matter of legal obligation, but a matter of good practice, at least for the time being, and until a body of experience and practice has been built up, which might obviate the need for application in every case. So clearly, in this very first case, the House of Lords was envisaging a time when not every case would have to come to the courts. But since that, in the passage of the mental capacity, the very long passage of the mental capacity bill, it was decided that it should be a matter of legal obligation. So what was originally a matter of good practice is now a matter of legal obligation. And so in every case where you intend to withdraw artificial nutrition and hydration from a patient in the permanent vegetative state or the minimally conscious state, you need to go to this. You need to go to the Court of Protection for the declaration of lawfulness. Now, the reason that we were interested in this and why we sought funding for Adam to help us think about this from a kind of legal and economic perspective is because it's not without controversy. Most doctors, according to the survey data and the formal pronouncements of the BMA, think that this is not a wise procedural requirement. They think that when families and clinicians are in agreement about letting a PBS patient die, that there shouldn't be a need to have recourse to the court. And in the literature, we drew out 4 specific criticisms of having this mandatory requirement for all cases. That England's out of step legally with other jurisdictions, that most other jurisdictions don't have a similar kind of requirement. That in any event, it's a requirement that's incoherent within the context of English medical law. That it could be distressing for patients' families having to go through this process, and that it's economically expensive for the NHS. And so one of our ambitions in this project was to try and assess these claims and look at the extent to which they're merited. But we also wanted to consider the contrasting claims in favour of having this procedural requirement. And they can be found back in that first case of Bland, where the court suggested that it was good for the protection of patients, for the protection of doctors, for the reassurance of patients' families, and for the reassurance of the public. So, our project has produced an article which I am delighted to say, has been accepted for publication in the Medical Law Review, and will be coming out in due course. It's not even hot off the press, it's hot in the press, and we're just at kind of pre-proof stage. And the aim of that article is to kind of comprehensively reassess these claims. And you can see that these claims are both legal and empirical. The legal claims are both doctrinal and comparative, and the empirical claims are both sociological and economic. So we wanted to develop a range of analytical methods to assess these things, and in light of that to advance an overall argument about the acceptability of this particular requirement. Now, That's the aims of the article. That's the article here. It extends to some 50 pages. It's over 14,000 words long. You'd be delighted to know I'm not going to go through it. So what I want to do in this paper, which is much more abbreviated, is just to literally to give you a bird's eye view of what we're trying to do in the paper, to sketch out the main arguments, to talk a little bit about our method of analysis in light of all those data sets, and then to outline what we think is the main argument that we want to make. So, and my ambition is that it will whet your appetite and that you might want to read more, which you will be able to do, I hope, in a number of months, or I think the paper might have been sent around, or I can certainly give it to you. Okay, so the paper goes through all 8 claims at some length, but what we then observe is that in relation to all these claims, there are sort of 5 main constituencies where the benefits, the costs and benefits of this procedural requirement are felt on the patients and the families of the patients, on the public more generally, on the doctors and the law itself. And I want to try and take you through what our main findings were in relation to that. And I should say, in relation to our data and the analysis of families, we're benefiting from a large interview data set that my colleagues Celia and Jenny Kitzinger have obtained from families of those with prolonged disorders of consciousness. So they've done, I think, about 60, 70 plus interviews with family members of those who have either had a relative in a minimally conscious state or a vegetative state and who have subsequently died or recovered, or who are still in that state. So we've got a rich body of data about family experiences and family responses to various things, and my analysis when it comes to that will be based on that. Okay, what about the patients? Well, the evidence here is mixed. It is probably the case that the current requirement of getting declaratory relief provides greater confidence in the diagnosis of PBS. So there's been quite a lot of, well, there's been a lot of concern in the medical literature about some literature in the medical literature, some pieces in the medical literature, about the accuracy of diagnosis. So there are 3 key studies that have suggested that the rates of misdiagnosis are about 40%. Now, and this understandably and rightly has caused alarm for medical lawyers. But we need to treat those cases, those projects with some concern. There are methodological problems with those studies that have been pointed out by a kind of senior clinician in Britain, a guy called Derek Wade. And in essence, what these, we have to bear in mind that the permanent vegetative state is a diagnosis that follows some time after an original injury that puts a patient into a vegetative state. So at least 6 months would have to pass if it's a non-traumatic brain injury, and at least 12 months would have to pass if it's a traumatic brain injury before the diagnosis of permanent vegetative state would be appropriate. And some of the cases in these studies, which are dealing generally speaking with small numbers, around 50 patients or so, the vegetative diagnosis relates to a time period before those cutoffs. So it's perhaps not surprising that we would then emerge from the vegetative state. So there are reasons to be sceptical about the rates of misdiagnosis that are reported in these medical studies. Similarly, our own discussions with the clinicians demonstrate, and this is also obvious from some of the clinical guidelines, that diagnosis is an instrumental business. So clinicians diagnose for particular purposes. And a diagnosis, for example, to move somebody from a hospital, acute ward, to a rehabilitation centre, is not necessarily going to be the same degree of confidence and certainty as a diagnosis towards withdrawing artificial nutrition and hydration. So in other words, just because there may be problems with diagnosis at an early stage of somebody's care doesn't necessarily translate into the same problems of diagnosis at the end of their care and at the end of their lives. So there's reason for the medical lawyers not to be quite so alarmed by some of these thoughts from the literature. Nonetheless, our interviews with senior clinicians suggest that the diagnostic process, and it is a process, is both complex and challenging, and that there is insufficient expertise across the whole of the UK to guarantee that that is done in an expert way every time. Now, the key thing here is that the process of going to court triggers a very expert review of the diagnostic evidence. So it would normally be the case that NHS trusts, before they go to court, will have an initial diagnosis that has been confirmed by an expert commissioned by them. And then the official solicitor, who acts as a litigation friend of the patient, would then commission a third expert review of the diagnostic, which is always a very senior and experienced clinician. So the level of certainty of diagnosis as a result of the court cases is very high, and it's just unclear whether or not we get the same level of certainty were it not for the court process. So it is probable that we would have less confidence across the board about diagnosis. So in that sense, declaratory relief is positive for patients and the protection of patients. But most of the cases that go to court, what happens is that the third expert simply confirms what the other two experts have said. To my knowledge, there's only been 2 cases where the diagnosis has changed as a result of the third expert. So for most of the patients in relation to whom applications to the court are being made, the reality is that the court application simply delays the implementation of a best interest decision. Now, that must in some senses be thought of as operating against their best interest. So in that sense, declaratory relief is not positive for most patients. And in addition, it's costly for the NHS. We've estimated, based on our interviews with barristers and solicitors who do this kind of work and with the senior clinicians who are involved in diagnostic evidence, we estimate that it takes on average about 9 months between a best interest decision and a court of protection decision. Now that involves costs in terms of ongoing care and in legal costs. And we've estimated that each case of declaratory relief takes about 9 years of QALYs, life years quality adjusted, from other NHS patients. So a QALY can be delivered by the NHS is estimated for around about £13,000. And we're estimating that each case costs about £122,000. So again, that's not insignificant for individual patients. That sum of £120,000 is tiny in relation to the overall NHS budget. But in terms of the impact of healthcare on individual patients, it's not insignificant. So, that's so much for patients. What about families of patients? Again, the evidence is mixed. Now, these court decisions are quite interesting. I originally read them as a lawyer read them, and some of you are lawyers. So, when you read a legal case, a legal judgment, you're immediately drawn as a lawyer to the doctrinal stuff. And actually, these cases are not very interesting in terms of doctrine. All the hard doctrinal work was done in bland. And so when you read these cases, they're generally short and there's very little in law. But then I realised I should be reading them more, not as exercises in doctrine, but more as cultural expressions. And when you start to read them as kind of cultural expressions, you see that actually the courts are doing what some scholars call therapeutic jurisprudence. So they're issuing judgments with a sense of the emotional impact on the families. So it's quite common in these judgments for the patient to be eulogised in a way. There's almost a funereal quality to some of the way that the judgments are given. And the families are given, are affirmed in their devotion to the patient, and they're also given assurance that the death is now the right course of action. And that kind of therapeutic jurisprudence can be effective. But the point is that these therapeutic, what could be called therapeutic jurisprudence, does make a difference, that people find it comforting and reassuring and affirming in some ways. In other senses, other families find the sense of due process significant. So in terms of a momentous decision for the family, they want it to be made by a disinterested, authoritative figure. That's significant for them. And yet, on the other hand, other families find the process very unwelcome. It's an unwelcome intrusion into their family domain. They don't think it is a legal business. Or they find the prospect of court proceedings intimidating, very much to be expected. Or they find the delay involved in between the decision to let the relative die and the actual implementation of that distressing. And for others, crucially, the process is both positive and negative. So in terms of assessing the significance of this procedure for families, it's quite a complex thing to do, and there's no easy, straightforward answers. What about the general public? Well, strictly speaking, the evidence is insufficient. We don't know what the extent of the need for public reassurance is in this country. There's very interesting evidence from the United States. There's a similarly well-known case in America of a woman called Terry Schiavo, of similar renown to the way that Anthony Bland's case was in the United Kingdom. And there were a number of public opinion surveys done at the time of Terry Schiavo's litigation around Terry Schiavo. So a number of 5 or 6 surveys, and they reported that between 27 and 42% of Americans were opposed to the withdrawal of nutritional hydration from Mrs. Schiavo, and that 29% viewed the withdrawal as murder. Now, we need to be very careful in reading across from American data to the UK scene, but it's at least suggestive of the fact that there might be, possibly is, a significant minority of English people who would be concerned with this thing. And certainly if you read the parliamentary debates, similar sort of concerns were voiced. But crucially, the capacity, even if there is this need for reassurance, the extent to which declaratory relief can provide it is simply unknown. And we actually suggest that it would be better coming from Parliament, and it would have to come from Parliament in any event. What about the doctors? Well, the Bland case certainly did operate to protect doctors from liability. That was clear in Bland. There was an attempt by a very prominent protester to force the hand of the magistrates to issue a summons for murder against the doctors concerned, and that was unsuccessful, citing the Bland decision. But declaratory relief no longer continues to do that. It's not needed. That's set in law. That's now part of doctrine. We don't need that to continue. So declaratory relief could be reformed without damaging the protection to doctors. And what about the law itself? Well, reform of the law would certainly bring English law into alignment with the international trend. We reviewed the English language literature, as much of it as we could find, and we also used a method of national rapporteurs to give us a basic snapshot of the procedural requirements in other jurisdictions. And as you can see, it's only really in Northern Ireland, Republic of Ireland and India that we find a similar procedural requirement. Even in Scotland, where the position I'm seeing is unclear, I would argue that there are grounds for believing that at least some doctors in Scotland don't believe that declaratory relief is necessary. Although it's best to regard the position as unclear. But there's a long list there of jurisdictions where a similar requirement is not required, where a similar requirement is not present. But perhaps more importantly, reform would remedy what is probably an incoherence within English medical law. So at a level of principle, this goes back to the best interest idea, at a level of principle, one of the core principles in English medical law is that where patients lack capacity, they should only be treated if it's in their best interests. And where a course of treatment ceases to be in the best interests of the patient, you would argue that it should cease. As soon as it stops being in the best interest of the patient, the course of treatment should cease. But this current procedural requirement involves that doesn't happen, that there's approximately a 9-month delay on average. And that is, I would say, problematic in terms of the coherence of medical law. And that argument is bolstered when we begin to look at some of the requirements for withdrawing CAN from non-PBS patients, non-MCS patients. So, for example, in relation to neonates or infants, there's no requirement to go to court for a declaration of lawfulness. or in relation to other incapax patients who are not PBS or MTS. Similarly, you don't have to go to court. The requirement also seems anomalous when you compare the withdrawal of other life-sustaining treatments, i.e. not artificial nutrition and hydration. So for example, the law on this is not absolutely crystal clear, I will give you that, but it is certainly the practice that when doctors choose to withhold antibiotics from a PBS patient who has pneumonia, for example, which is not uncommon, they don't go to court for a declaration of lawfulness, nor in relation to withholding CPR. So it seems that the law has tacitly accepted that those kind of treatment decisions can be made, and it's only the artificial nutrition and hydration ones that require the court's approval. So, those are our findings. That's a summary of our findings. What do we do about them? How do we weigh them up? How do we come up with a recommendation in light of that? Now, I think the first thing to note is that some of these benefits that are gained by the process can be achieved by other means, and so reform of the process wouldn't necessarily mean sacrificing all of these benefits. So in terms of the therapeutic benefits that some families get from the court process, they could be obtained, we suggest, through better, more formal, better considered best interest meetings. And that indeed is a recommendation of the recent clinical guidance of the Royal College of Physicians that best interest meetings should take place, recognising that families will need a certain amount of emotional, psychological support, and that anticipatory bereavement work may also be required. So in terms of the ceremonial function of moving a family on from this kind of living death to full death, that could happen in another setting. So better best interest meetings could render the therapeutic justice work of the court unnecessary. I suppose that's our point. And in terms of reassuring the public, we argue that that would be better achieved by aligning the substantive law in this area with the procedural law. So in terms of substantive law, the provision of artificial nutrition and hydration is a medical treatment. And its withdrawal is the withdrawal of medical treatment. So in that sense, A&H and PBS patients is like any other medical situation, and yet it's the only circumstance where you have to go to court to get the special declaration of lawfulness. We argue that the public would be better reassured that this is that the ordinary principles of medical law apply by not having this disconnection between the substantive and the procedural law. So in a sense, the law is actually giving out mixed signals. On the one hand, it's saying the cause of death is the original injury, and this is just a withdrawal of treatment. But on the other hand, they say, but you still need a declaration of lawfulness, so that's okay. And as we said before, that reassurance should best come from Parliament, and actually would need to come from Parliament in any event. So, we're left with some remaining considerations. How do we balance them? How do we balance the idea that declaratory relief gives us greater confidence currently in PBS diagnosis versus delayed best interest implementation, foregone care for other NHS patients, and distress for some families? Well, law and legal scholarship is very fond of the metaphor of balance. We love the idea of balancing things out. Indeed, if you were trying to make a best interest decision for a minimally conscious patient and deciding whether to allow them to die, the court formally has to do a balance sheet exercise. But although the balance metaphor is evocative and reassuring, it's ultimately probably false and misleading. You can only balance things if you have a common unit of measurement. So the truth is we can't balance these considerations. And so we have to find an alternative approach. We have to zoom out and think about what medical law is doing within its broader socio-legal context. And we think it's helpful to ask us, what function is the court doing here? In fact, it's better to probably ask that in the negative. What is the court not doing? And we know that the core bread and butter business of the court is in making best interest decisions in difficult cases and in considering claims of professional negligence by doctors. Now that's what the court's good at. In the grand division of labour, the courts are experts in that. But that's not what's happening in these cases. The best interest decision about PBS patients was made in Bland All that work has taken place. It still happens in relation to MCS patients, but not PDS patients. What the court is doing in these cases is it's directly supervising a medical diagnosis, really as a matter of proof. Now, you can imagine in cases of dispute that's justifiable, but we can't think of a principled reason out with cases of dispute why that should be the case. In the grand division of labour, medical diagnosis is a matter for the health system and not the courts. And we see that in relation to the fact that the law does allow diagnostic decisions that will lead to death in other patients without, the law allows them to happen without direct court supervision in quite comparable cases. So ultimately our argument is that reform of this law is needed on those bases. I'll stop there.
Thanks very much, Simon.
Later.